This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number.
To accept this free call, press 1. To refuse this, thank you for using Securus. You may start the conversation now.
Hey, how you doing?
Good evening. This is Criminal News Network New Haven. I went to court today. Oh my God. What? I have to get up and go to court? Wait a minute. It's not the 17th. What's going on? Oh, so we argued a motion to compel. Oh, fuck you, Mr. Todd. You're not getting anything, says the judge. Then there's a emergency motion for stay of the bond elevation, which the judge said, fuck you, Todd. And evidently, I didn't understand it at the time. The judge said, well, let the appellate court do its job. Well, it turned out on Friday, Toddler filed a stay with the appellate court and emergency stay, which you might be able to retrieve if you can navigate through the jud.ct.gov website and go to the appellate section, pending cases, and probably type in Boyne for a party name, or you can type in the
So Todd divested the Brown of jurisdiction.
say what?
Todd divested Brown of jurisdiction on an emergency bond application.
I don't know what that means.
He basically said that something's pending in the court above me in the appellate court. Let's let the appellate court do their work. I don't have jurisdiction now because you brought it to a higher court.
No. He denied it. You can apply in both courts at the same time.
Okay.
And he denied the trial court and just said, fuck you, let the appellate court deal with it. And but I'm saying you can pull Todd's motion. I mean, the one I saw, my God, it was, I flipped through it. It must have been 10 or 12 pages, and all the familiar things about bond and the Eighth Amendment. So if you want to pull the one off of the appellate, you can get that off of the website.
Do that. Yeah, I'll do that now. No problem.
Yeah. Well, here is. Oh, and let's see. Luthman was mentioned. I don't know, 9 times. Emails from Luthman. Katz forwarded Luthman's emails to Jack. Jack has never had a conversation with Katz. No one from state police has ever taken a complaint from Katz, and they'll probably decide tomorrow that they're not going to call Katz as a witness. Right. But we know Jack doesn't talk to Katz. He's too low on the totem pole. But here's the fun one. And I don't know what we should do with this. Jack has said that McCord was the only state trooper from Connecticut. Very, very emphatically, quoting people from the Connecticut State Police. Mm-hmm. Well, the stuff that was seized in the SWAT raid wasn't logged in Connecticut until the 21st of July. So it was 3 weeks after the raid. Now, I know the week after, when we were in front of the circuit court in Virginia, they said that McCord was on vacation. Mm-hmm. And somebody let it slip to me today that McCord's girlfriend is not a police officer. So this mysterious second person who was at the raid wearing a fleece with, Connecticut State Trooper embroidered on it, just like McCord, I think that's McCord's girlfriend.
Really?
And yeah, because this is the big mystery thing. Nobody, Jack is swearing up and down that McCord was the only police officer. Well, that's true, because the other person wasn't. And then where did they go? They went on vacation.
Wow. So she was truly a tourist.
Say what?
She was truly a tourist.
Hey, I couldn't hear you there. Say again.
She was truly a tourist for all purposes.
No, I'm talking about why the fuck was some civilian in my kitchen?
Well, it's the same
With
thing because as far as the Virginia law is concerned, Sammy McCord was also a civilian. They were both tourists.
no. I got that part with Sammy, but I don't get the part with why she dragged her girlfriend along, and then why that girlfriend was presented to me as being, from Connecticut with McCord. And now here's the other part. They think that they went on vacation. So where was my shit between June 30th and July 21st? In the back of the car at the beach?
Wow.
Yeah, that's the wow. And so, anyway. I thought maybe what you could do with that one is make an inquiry to Tom Lambert. He's the Virginia State Police legal in-house guru. They've also got a gal named Robin Lawson, who is the director of PR for Connecticut or Virginia State Police. And ask him why, to make a comment on why the hell, what was going on during that raid. But, yeah, I mean, that kind of puts Sponheimer in a, oh, excuse me. Yeah, sick as a dog today. Anyway, so I think that's the big thing. The rest of the hearing was total shit.
Are they going to revisit your bond on the 17th, or has that changed now?
I think it's the 18th now. I couldn't quite understand what Ron Boy was saying. But he was not in a good mood today, that's for sure. Oh, and then just between you and me, all right, Todd actually said he's going to file a motion to disqualify Brown. Do you believe that?
Really?
I don't. I said, yeah, talk is cheap, Todd. I'll believe it when I see it.
Yeah, me too. I'll believe it when I see it. Holy cow.
Yeah.
So we have to wait for the appellate court to rule, but they may not rule on this.
I don't think they're going to rule on it because I said, the appellate court hates me just as much as the entire judge club hates the blog.
Yeah.
And what are they going to do? They're going to come and say, oh, wow, $1.5 million bond. Well, that's okay. No, they're not. They're just going to ignore it. And so, I mean.
So
anyway,
what did Todd say to you about the articles, if anything?
The only thing they actually mentioned to me was Volpe had sent something out with a bunch of links on it with my recordings from, I don't know where, discussions from prison. And I guess he'd sent it to a bunch of people. And Jack actually asked Todd if he had gotten it. And of course, yeah, Todd had gotten it, but he didn't even bother to read it. So, and then actually nothing about the blog article on this. I was talking to Todd afterwards, and I said, well, Monday was kind of a banner day because of what they did to Dave Weigel. And then he mentioned the judge's name, and he said he saw the article on the blog about that. So I imagine he saw the other articles too. I mean, he keeps up on it.
Okay.
But they didn't mention anything about that in court. But they did mention, all these emails from Luthman. Oh yeah, it's Luthman. And so I'm like, what difference does it make? Why are you people so hung up on this shit?
Well, they got nothing better to do. That's the point. That's the problem.
Yeah.
And they got nothing better to do, and they know that I'm
criminals
asking
out there.
questions. They know that I'm asking questions that they can't answer without, big problems happening.
Oh, by the way, I got the form for the federal habeas. I might fill it out tonight, and I can file it from prison. I mean, I already know what Dooley's going to do. She's going to say, no, this is an issue for the state, not the feds. Oh, they put you in $1.5 million bond? That's not a federal issue. No, Eighth Amendment? No, not federal. I mean, you know what she's going to do.
What I would do if I were you is file a declaratory judgment action in federal court.
Well, I
As
think in the habeas you can ask for that. You know, declaratory and injunctive relief is what you'd be asking.
no. I would file it under 2001 the federal rules. I don't know 2001, but what's one of the federal rules? I think maybe 6,000 or 60 something. But
Yeah,
you can
I
ask
know
for.
that's declaratory relief.
It's not in the form of a habeas. It's an actual claim for declaratory judgment that the statute itself, the stalking statute, is unconstitutional. That's how you would bring an unconstitutional claim.
That ain't gonna help me between now and next week. They're not. I mean,
Yeah.
you know, I mean, we filed for declaratory relief in state court because, you know, Dooley basically said, hey, your remedies are in state court, and we filed that. That was Boyne v. Lamont, and Schumann shot it down. You know, it's like, oh, you're asking us to declare this unconstitutional. No, we're not gonna take that up. That's what he said. So, I mean, you can pull that one down. It's up there on. It was filed in Hartford, Boyne v. Lamont, and but do pull down whatever he filed with the appellate court.
I have it already. I have it in front of me, so I'm going to pull it out. I'll have an article out on this without question. So I'll have an article out on this without question. What I wanted to do was I wanted to put out the article. I was talking to you about the how the Jews killed Kennedy, or your theory on that, and I wanted to put out another article on that. Now we're about 12 minutes. Do you get a chance to call me back on another call if we get cut off?
Oh yeah, they killed the phones at lunch. I was on there a little late. Yeah, no, I can give you a call on that. There's guys in line for the phone, but yeah, I'll call you back on that with all the gory details and the names of the people who did it.
Yeah, we'll start it up again. I know we started talking about that, but we'll do it because I think that the point of that story will be this is Paul Boyne's theory, and it's akin to some of the theories that he's criminalized and incarcerated for, but they're no different than some of the theories that have been presented by Tucker Carlson and others. So I'm going to make the media argument out of that. I think it's a great story to tell. It's a good story, and it makes an important point about the line between journalism and criminalization.
Yeah. Well, you did look up what a journalist is in the practice book of Connecticut, right?
Oh yeah.
You're not one, according to those assholes.
Oh.
You know, and it's a rabbinical. It's a yeshiva. You know.
Yeah.
You're not media. You can't come to the courtroom. You can't set up a camera. You can't record. You're not me. You're not the press. You know, that's what they're saying. And
the declaratory judgment I was thinking about was that practice book section that you were talking about that says that they can make rules in the practice book so long as it doesn't abridge fundamental rights. The rule that he used to deny that he denied the Brady issues that Brown did, you could bring that as a declaratory judgment, stating that I think that might be something that you can do.
Well, I mean, you're talking in federal court.
Yeah, bring it in federal court. Why not?
Yeah, I'll put that on my list. But we're actually 14 days from trial.
That's crazy.
Supposed to start.
You have 1 minute left.
Yeah.
But anyway, well, you got the news for today, and
when are you going to give me a ring? You can ring me tomorrow?
Yeah. Tonight's phones are backed up.
Okay.
So I'll try and catch you tomorrow.
All right, sounds good.
See ya.